Thank you, Amber. Good morning, everyone. I'm Andrea Barton-Reeves, and I'm the CEO of Connecticut's Paid Leave Authority. I want to thank you for having us this morning, and I appreciate you being online and up at 8 o'clock. I know that's a big ask, and we appreciate it. So this morning, I will walk through the basics of paid leave, and then we'll have a chance to address any of the questions that you have. Amber Forrest is our very able executive assistant who's here with us today. And what we ask is that you use the Q&A feature for questions rather than the chat. That allows us to answer the questions directly and share them with the others in the webinar if we need to do that. And it also allows us just to answer specific questions to a particular person, which we cannot do in the chat. So I am actually going to turn off my camera so I'm not a distraction during the webinar, and I'm going to pull up my PowerPoint presentation and we can get started. All right, let me share my screen. Okay. Amber,
right,
you'll let me know. We're good?
You're all set.
Okay, thank you. Let me hide the controls. The slideshow mode. All right. So again, this is a webinar that covers the basics of the Connecticut Paid Leave Act. It will answer some questions that you have about timelines. We'll have a very brief discussion about private plans, and then we'll answer questions that you might have. As I mentioned earlier, my name is Andrea Barton-Reeves. I am the CEO of the Paid Leave Authority. I began in this role about a year ago on March 2nd. Prior to coming to the authority, I was the CEO at HARC, which is a large nonprofit that supports people with intellectual and related disabilities. I have lived in Connecticut for the last 25 years. I have a degree in English from Rutgers University. I'm from New Jersey, and I have a law degree from New York Law School. As I mentioned earlier, we will be talking about the program, giving a brief overview of the leave laws, the role of the employer, how a person might apply for those benefits, just a very brief overview of leave in the workplace. We'll have a discussion about private plans, registration, resources, and then a question and answer period. So the authority was established by statute in July 2019 when the law was signed by Governor Lamont. Paid leave itself is designed to do two things. One is to provide a pathway for families to have accessible ways to access paid leave. And the second is to have employers and administrators and healthcare providers understand the law. And we do that by providing support so that they can navigate the program successfully. We have 5 primary responsibilities at the Paid Leave Authority. They include outreach and engagement, which we're doing today, so thank you again. We develop the policies and procedures that are needed to administer the program. We also established the trust fund contribution rate, which is no higher than 0.5%, and we receive those contributions into the trust fund. We approve and audit private plans. We also administer claims for paid leave benefits. Here are some key dates that you should know about. Employer registration began in November, and prior to this, our website was launched in September of 2020, and that's where you can find an enormous amount of information, including everything I'll cover here today. Deductions, the 0.5% from employee wages, began on January 1 of 2021, and we can talk about what happens if you haven't done that yet. Some employers have opted for the private plan option, that is an ability to create their own paid leave program that aligns and is in compliance with the statute itself. And we have employers that are doing that now. Your electronic payments, meaning the remittance of the 0.5% that's being collected now, is due at the last day after the end of the quarter. So the quarter ends on the end of March, and we give a 30-day grace period at the end of each quarter to submit those contributions. Starting at the end of this year, those that have contributed and sole proprietors and self-employed individuals who have opted into the program can begin to submit their applications for benefits. And those that have approved applications can begin to receive benefits starting in January of 2022. Which employers are required to participate in the program? They're known as covered employers, and they include employers who have one or more people working in the state, and that's even if your business is headquartered elsewhere. That includes nonprofits and private sector employers that have unionized workforces. Those that are sole proprietors or self-employed individuals can choose to opt in, but if they do so, they have to remain in for a period of 3 years at a minimum. Those who are not covered include employees of the federal government. Obviously, the state cannot tell the federal government what to do. Some state employees, except those that are covered public employees, municipalities, and local or regional boards of education, unless they too have covered public employees. Non-public elementary or secondary schools are always exempt from the paid leave program because they have always been exempt from family and medical leave in general. So a little more clarity under the law with respect to covered public employees. They are all of the non-unionized employees of the state of Connecticut, and those unionized employees who collectively bargain to be participants of the program. Those that work for municipalities or work for local or regional boards of education are exempt from the law unless those unions collectively bargain to be included. And if they do so, then everyone who works for either the municipality or the local or regional board of education, whether they are in the union or not, is then included in the program. So a word about sole proprietors and independent contractors and the applicability of the law to them. Independent contractors and sole proprietors are not considered employees under the paid leave law, and therefore they do not have to pay into the program. And the parties that they work for, with whom they are in contract, do not have to withhold the 0.5% contribution from any pay that they pay independent contractors. Again, they have the option to participate at any time, but if they do so, they have to remain in the program for 3 years. The same is true for sole proprietors. They too are not considered employees under the law and do not have to participate or pay into the program unless they choose to do so, and they have to remain in for 3 years if that is the choice that they make. If sole proprietors, however, have employees, then those employees must participate in the program, although the sole proprietor has the option to join the program or not. A bit about what happens to the 0.5% of the wages. Those are collected by the employer, as I mentioned earlier. They are remitted according to the due date schedule that we saw in the earlier slide. The Pay Leave Authority then receives those contributions, and we validate the wage information with data that we have from the Department of Labor and the Department of Revenue Services. The contributions are deposited into the Paid Leave Trust Fund, which is managed by the Office of the Treasurer. And the benefits that I spoke of that will be available in 2022 are paid directly from that trust fund. So an overview of the law itself. These are the reasons for leave that can be taken under the new Family and Medical Leave Act. You can take leave to create or expand your family through birth, adoption, or foster care. You can care for a family member with a serious health condition, which is also known as caregiver leave, or your own serious health condition, which can include serving as an organ or bone marrow donor or pregnancy. There is special leave available for those who are serving our country. A family member can take leave to care for another who's been injured during active duty, and family members can take leave to be with a family member that is being called overseas to active duty, known as qualifying exigency leave. And what is unique to Connecticut's law is that up to 12 days of leave can be taken for those who are victims of family violence. So what are the eligibility requirements for the paid leave program and for family and medical leave in general? Keeping in mind that family and medical leave applies to employers that have one or more employees. So looking at the left side of the screen, a person is eligible for what we call job protected leave. That means that they get their job back when they come back from leave, whether they take paid leave or not, if they've been with the employer for at least 3 months, and there is no hours worked requirement. And for larger employers who may be familiar with this, with current family and medical leave for the state, you have to work at least 1,250 hours, and you have to have been with your employer for a year in order to have job protection. That will no longer be the case in January of 2022. To access paid leave benefits, you have to have earned at least $2,325 in the highest earning quarter of the past 4 of the 5 quarters before you apply for leave. You have to have one of the qualifying reasons that I listed earlier. And when you apply, you have to either be working in the state or you were working in the state in the past 12 weeks prior to the time you apply for benefits, or you're a sole proprietor or self-employed that has opted to participate in the program. The lengths of leave are these. There's basically the same for job protection and paid leave. It's a 12-week leave in a 12-month period, except for military, which is up to 26 weeks in a 12-month period, but only 12 of those weeks are paid. Family violence leave can be up to 12 days, and there's an additional 2 weeks that might be available over the 12-week period if there is an incapacitation that occurs during pregnancy. When you're accessing the paid leave benefits, these exact same timeframes also apply. Another important distinction between the current law, which some of you may be familiar with, and the law when it will change to 2022, is that it will have a much more expansive definition of a family member. And the leave will be applied if you are taking time to care for a parent, a spouse, a son or a daughter of any age, because it is now limited to 18, a sibling, which is not covered now, a grandparent or grandchild, again, a category of family member that is not covered by the leave law now, or an individual that is related to the employee by blood or affinity, whose close association is the equivalent of these family relationships. A clearer definition of what related by affinity means. It means any person with whom the employee has a significant personal bond. That is one like a family relationship that's in the statute, regardless of the biological or legal relationship. It's obviously dependent on the situation, but the example that most people find most accessible is the second bullet from the bottom, where you may have a couple that is living together and they may have done so for some time, but they are unmarried, but they do have a familial spouse-like relationship and may need to take time off to care for one or the other, which is not something that's permissible now under our current family and medical leave statute, but that will be the case when the law changes in 2022. Let's talk a bit now about benefits and accessibility. So how does a person get access to the paid leave benefits from the authority? They apply directly to the paid leave authority for those benefits. We then validate their eligibility based on the earnings number that I mentioned earlier, that 2325, and that they're taking leave for a reason that is covered by the statute. That's also validated by paperwork and documentation that the person must bring to us from a healthcare provider. We then do a preliminary calculation of what their benefit amount may be based on the formula in the statute. We then calculate that preliminary amount, and then we communicate with that person's employer to determine that they've informed their employer of their actual absences, that those absences are covered, and to see if there's any other leave time that they should be taking that can offset the benefits that they're receiving from the paid leave authority. Some employers require their employees to use their time for family and medical leave to avoid them stretching out the time to use it at a different time, which is also known as stacking. So we would want to talk to employers about that. What's important to know here about the paid time and the time off is that if a person has time and your policy is that you require them to use their time for leave, the statute requires that you allow them to keep up to 2 weeks of their leave. They can hold that in reserve. They're not required to exhaust all of it. Once we've done all of that, then all of our verifications and validations, then we issue the paid leave benefits. So here are some examples of how the formula would be applied. If you have earnings that are less than or equal to the minimum wage multiplied by 40, which is right now $480, then you receive 95% of your weekly pay. And here we have Mike that makes $375 a week. And so he would receive $356.25 in weekly benefits. Deborah makes more, and the formula is a bit more complex. She receives at a minimum the 480, and then she receives a percentage of the difference between the 480 and her wages. And so she would receive $612 a week in benefits. Again, so here's the formula without the examples, just so it's a bit clearer as to what the formula looks like in the statute itself. So some facts about income replacement. We know how to apply. We have a sense of how much it will be. So then what happens if you as an employer are offering other types of benefits? You can coordinate those benefits with short-term, long-term disability, any other kind of benefit a person may have, but together with whatever a person receives from the paid leave authority, those benefits cannot exceed 100% of their regular wages. Some short-term and long-term disability policies that some employers may offer may require a person to exhaust their state benefits first. So we would be checking with you to know whether or not that is the case. Workers' compensation and paid leave do not work together. So if a person is receiving workers' compensation or unemployment benefits, they are not eligible for those paid leave benefits while they're receiving workers' comp. I'll talk a bit more about private plans. And as I mentioned earlier, a person can be required by their employer to use their sick, vacation, and other PTO to cover their time off. But if you do so, if you do require them to do so, they are entitled to keep up to 2 weeks of their leave. So let's talk a bit about private plans. Some employers are choosing the option to offer their own plan in lieu of the state plan, and they can do so under certain circumstances, excuse me. Those circumstances are defined by the statute. If an employer has a plan that's approved by the paid leave authority, then they are completely responsible for all aspects of that plan. They would approve the employee's claim for paid leave benefits, but those employees would not be required to remit any contributions to the authority. If an employer chooses to fund the plan themselves, they may do so, or they may also withhold a portion of the employee's wages, but no more than the 1/2 of 1%. And that money can only be used for the purposes of administering the plan. So that would be to cover the cost of administering the plan, to help offset those costs, or to make your own contributions to the fund through what you're withholding to pay benefits to employees. You choose to set up a private plan, and some employers are. Some small employers with only one employee in the state have applied, and very large employers have. So we've seen the whole spectrum. You would do that by going to the website and choosing the option, I want to apply for a private plan. If you do so, you should know that your plan has to offer same or better benefits of the public plan, and a short-term disability policy usually does not suffice because it does not meet the statutory criteria, and the plan has to be approved by a majority vote of all the employees working in Connecticut. And that is also another reason why a short-term disability policy doesn't usually meet the criteria of a private plan. If you do choose to submit a private plan, here is a brief summary of the process. You would register now and let us know that you have an interest in applying for one. Then before you apply, you can select an insurance policy or a self-insured plan. There are 16 insurance companies that are offering private plan coverage in the state of Connecticut. You would educate your employees through something called the Plain Language Guide, which is also available from an insurer or a surety if you have a private plan that is self-insured, and you have to hold an anonymous employee vote. After you've done those 3 things, you would then go back to our site on My Account, click your business name, and then follow the instructions to upload your proof that you've done the 3 things that you need to do before you can apply, and submit your application for approval. So I've spoken about a lot of things, but none of these things happen unless you can register your business, which we need all businesses to do. So registration assures that you can remit your payments. Payments come directly to the Paid Leave Authority through our website. They do not go to the Department of Revenue Services or the Department of Labor. And failing to do so could mean that your business might be responsible for making up those missed contributions. The businesses do have until the end of the second quarter, so that's essentially the end of June, to make up whatever hasn't been withheld by holding up to 1% of an employee's pay to catch up if you haven't started by January, actually the beginning of last month. So a failure to withhold or remit those contributions may affect an employee's ability to receive their benefits, because we do look to see whether or not a person has contributed to the paid leave fund. So we don't want to impose any further penalties for a failure to withhold. That penalty really looks like our coming back to you and saying you didn't withhold, or according to our records, you have not withheld enough. So we need to talk about how we're going to make up that difference. That's not a conversation we want to be having with businesses. So we're asking everyone to register and withhold as soon as you can. The registration process is really quite simple. It takes less than 10 minutes. If you go onto the website, and you'll see the registration button is right on the very front page. It'll ask you to create an account at business.ct.gov, which is really simple to do, and then complete your registration process. Now go to our site, download the checklist that'll tell you what you need before you even get started, and then register your business. I know I've mentioned a lot, but there's also a lot of information that is available on our website, and some of them I have listed here and in the slide around information resources. So if you need to educate your employees about what's happening with paid leave, if you go to the employer page of the site, you will find all of these documents. An employee rights poster, which is a comprehensive document summarizing everything that I've spoken of, and what we call a RAC card, which is a smaller version of that, which some employers are choosing to use. The paycheck mailer is a brief summary of what that 1/2 of 1% does. And this QR code is something that an employee can scan, and it takes them to what's known as a contribution calculator. You can see what the 1/2 of 1% is, so you don't have to keep answering that question. But everything that I've spoken of today is in this employer toolkit, which is available for downloading in English and Spanish, as is the entire site. Again, the site is ctpaidleave.org. And again, I will ask if employers can engage in this immediate action checklist, which is to register. So if you're using a payroll provider, to please contact them and make sure that the withholdings have begun. All of the major payroll providers already know about this. We've been working with them for close to a year. To educate your employees using some of the documents I outlined earlier, that's on the employer page of the site, and to visit the paid leave site regularly for updates. We're here to help you. We don't have a call center, but we do have a contact center that you can reach through using the Contact Us feature on our website. There's also some frequently asked questions and a number of helpful videos that are on the site as well. Thank you for the opportunity to talk with you. I'm going to stop sharing my screen and answer any questions you might have.
Thank you so much, Andrea. So we do have a question here in the chat, and it's a two-part question, so I'll start at the beginning.
Okay.
I understand that the authority must approve a private plan application by 3/31/21 in order for employers to not need to pay contributions retroactive to 1/1/21. Is there a required or recommended date that the application must be submitted by to allow time for the authority to review?
Yes. So my colleague, Erin Choquette, who is our general counsel, always answers that question with now. So we'd like you to do it as soon as you possibly can, but please, I wouldn't wait any longer than March 15th. That's probably a good date to allow us to review the plan, because as I mentioned, payments are actually due on March 30th, but we have a 30-day grace period, so that would give you a 45-day window to submit your contributions that you've withheld if in fact your employees do not approve the plan. But I wouldn't go any later than March 15th. If you need more time than that, then you should really contact us directly, and then we can work with you. But that's the date that we would recommend.
Okay. So the second portion of this question is about missing that deadline. If I miss the 3/31/21 approval deadline, when is the next date that my private plan application may become effective? 4/1/21 or 7/1/21?
Yes, it would be starting, we're trying to approve them by quarter. So it would be the next quarter. So you would be right with the 7/1/2021. So again, if you can get it to us by May, if that works, or because your payments are due at the end of April, if you can get it to us anytime prior to that, your next effective date will be the July 1 date. But I want to double check that because I know we've gotten some feedback. We were trying to move some dates around, but that's the date right now.
Okay, great.
Mhm.
So in regards to that July date, as of what date would that application need to be approved for effective date? And I think you said July 1st?
Right.
Okay. All right. And what would be the recommended submission date for that second quarter? Or should we say third quarter?
I would say it'd be June 15th
Okay.
at the latest.
Okay, great. All right, everyone. Does anyone else have any questions? I know we're all kind of sleepy. It's Friday, TGIF. It's
Yeah,
snowing out in
it's
Connecticut
snowing. Yeah, it's
again.
snowing. I
If
know.
you do have any questions, we just want you to know we are here to help you. I'm going to give everybody a minute to think if they have any questions. I'm going to drop a few links in the chat for you. One to our calendar of events in case you want to go to another webinar, learn a little bit more about the program. I'll also drop a link in there for the employers where you can find the employer toolkit that Andrea was going over in the employer resource section of the presentation. So I'm just going to give you all a minute to see if anybody else has any questions, and I'll go ahead and put these links in the chat for you.
And I think, Amber, if we haven't already, I think Erin has another webinar that she will be scheduling on just private plans. I don't know if she has another one this month, but I think we can schedule another one for this month, and those are very helpful. So our
Yes, they
general
are.
counsel offers a webinar that's just on private plans. If you've not been able to attend one, that we do put them up on our website, on our events page, and you can actually click into that link and then see a recording of one that she's held before. And that will give you all of the details that you need. It actually walks through how to apply. It gives you a detailed overview of the forms, what we're looking for approval. Approval usually happens within a 10 to 14 day time window. We've actually been approving them, or making a decision, I should say, on approval within a week. So it's not been a very long time. With that said, though, we've not had enormous volume, but as the number of applications increase, it'll probably take us a bit longer. But we know you need to make a decision fairly quickly, so we're trying to move through them as soon as we get them.
Yes. Also, we do have pre-recorded webinars from our past webinar opportunities, which you can also find on YouTube at Connecticut. And I'm going to drop this in the chat as well, but it's
Okay.
Connecticut paid leave. And the Connecticut portion is completely spelled out, but you can check us out on YouTube as well. And all of our pre-recorded webinars are there. So seeing that we don't have any other questions, we'll let you all have another half hour back to your day. Happy
Yep.
Friday. And thank you so much, all of you, for joining us. We really appreciate
Thank
your
you.
time.
We really appreciate the opportunity. Thank you so much.
Yeah.
Bye. Have a good weekend.